Y ahora es el momento de hablar de Sarah Pearce, quien es partner en Paul Hastings, especialista en Privacy and Cyber Security Practice, lidera el equipo europeo de Paul Hastings. Sarah Pearce, ahora lo haré en inglés, is a partner in Paul Hastings, specializing in Privacy and Cyber Security Practice. Es además, she's a head up Paul Hastings European team from firms London and Paris offices. She will talk us about European regulations. So, Sarah, nice to listen to you.
Thank you. Can we go back to the beginning of the slide, please? It's in the middle. So, Vanessa.
Vanessa, podemos ir a la placa anterior. Ahí va, al principio.
Thank you. So while that's happening, there's a lot of slides. I won't go into detail on everyone. And hola is about the extent of my Spanish. I'm sorry. I'm ashamed. I speak French, but not Spanish. But lovely to be here. Thank you for your time. There are a lot of slides. As I say, it's a big topic, but I won't go into detail on all of them. We'll just do an overview and a run through. I want to focus, I've been asked to focus on the healthcare aspects of data protection. So I'll spend a bit more time on those particular slides. So as I've been introduced already, yes, I head up the European and UK team here at Paul Hastings for data privacy and cybersecurity. So next slide. There we've got an overview of the various topics that I'm going to run through. Next. Next. Starting with the data, just a map of the world, as you can see, looking at where data privacy, data protection laws have been implemented. So we're getting there. So there is a majority. There are some countries, it's namely sort of Africa generally, that are lacking in any data protection legislation, but we are seeing moves, particularly this year, to have some legislation in place. So it's one to watch. Next slide, please. Here we've got the basic key concepts that seem to be running through the majority of data protection legislation that's coming forward. And we'll see, as you'll see in the further slides, you'll see there's mention, we'll go into a bit more detail on each of these and how they apply to the healthcare industry and also particularly in Spain. So next slide, please. Next. So here we've got an outline of the key definitions. Now, I've picked on these key definitions because they are the key definitions that exist in the GDPR. Now, the GDPR is the European-wide legislation that I'm sure you may have heard of. The letters stand for General Data Protection Regulation, and it is a European regulation that is directly applicable in each member state of the EU. So we in the UK had this law up until fairly recently and Brexit. We do still have a version of the GDPR in the form of the UK GDPR, in fact. So the same principles apply. In the EU, I've focused here on the EU GDPR, however. So you've got on the slide various definitions. Personal data is the key one. What are we talking about here? It's data that can be used to identify any individual, basically. So you can use my IP address to identify Sarah Pearce, me. It's anything that can identify a person and a living person. Then health data is actually called special category data, and we'll see that shortly in the text of the legislation. That's ordinarily sensitive data about someone's health. So anything you can imagine goes to biometric, genetic, sexual preference. It's anything concerning your health. Processing is any activity to do with processing, whether you just, if someone can access it, that falls under processing and is caught by the act or legislation. Controller, now this, and next slide, please. Next slide, thank you. Controller, processor, and joint controller. Those two, processor and controller, you can see on the screen there. These are the roles of the parties played in respect of processing data. So it depends what is happening to the personal data. So for example, if I send it by email to someone to do something with it, they are going to do that something with it and then send it back to me. And that I am a controller and the other party is a processor. You can both act as joint controllers, but there are additional provisions that will apply. And I'll just cover off a bit later how each of those roles usually is expressed in the context of the healthcare industry. Next slide, please. And the next. Thank you. So here we've got looking at one of the key areas, as I mentioned, of the looking at the legal basis for special category data in particular, because special category data is, as I mentioned, it includes health data and it's quite sensitive data generally. So there's additional requirements that have to be applied to it. So under the GDPR, you need an Article 6 condition. That's what it's called, an Article 6 requirement, an Article 6 lawful basis to be able to process the data. And that is, you know, it can be because you've got a contract with the person and you've committed to do something with that data. In the health world, we often look at public, and this is particularly relevant in the last year, because we often look to the use of health data for the public interest. So it's often in, you know, if you think about COVID and various vaccine tests and vaccine rollouts and so on, they were largely implemented or carried out on the basis of the public interest. There were certain acts and processing activities that needed to be done in the public health interest. Now, that's not to say there aren't other bases, and consent is one that is also commonly used in the healthcare world. However, in addition, where you are processing special category data, so health data, you do have to have what's called an Article 9 condition. Okay, that's an additional requirement, whether or not you've got consent. So it's you have to satisfy two requirements. Next slide, please. Data subject access rights. I won't spend too long here. These are the same for generally any data that you process. You get, some of these are automatically attributed to any data subject and they can action them. Some depend on what lawful basis is being used for the processing activity. Next slide, please. Next slide. Thank you. So we've got here sorry, my email keep coming. We've got the right to erasure, and I'm going to, Vanessa, can you move through quickly the next few? Erasure, rectification, they're the key ones. Now, if we look at the controller obligations, the next ones I've just decided to look at is the obligations of the parties. I mentioned earlier about the roles of the parties, and that matters because depending on what role you play in that processing activity, so depending on what you're doing with the data, you have different obligations on you. So if you are a controller, the obligations are in this slide. Next. Now, privacy policy, you'll see there, is key. That won't surprise you. You've probably seen a wealth of privacy policies. The controller can deal with, one of the requirements of the law is to be transparent about what you're doing with the data. And one of the ways of doing that is putting together a policy or a detailed note of what you're doing with the data, so that anyone whose data you're using and processing can understand and knows what you're doing with that data. In Spain, it should be in Spanish. Next slide. This one is about the record of processing. Controllers must keep a record of processing activities. That's called an Article 30, for those that want to know, record of processing. And there you've got the details that need to be included. Next. Next. The data protection officer, that will be required, particularly if you're processing special categories. There are certain requirements to appoint one, but generally speaking, if you're processing special category data, certainly on a high level, you should be appointing a data protection officer, a DPO, or a CPO, Chief Privacy Officer, it's sometimes called. Next. Data security is a key one. You do need to implement technical and organizational measures to keep the data secure. Now, you've often probably heard, particularly in recent years, of data breaches and the security. It often happens because there is a lack of security. Ransomware attacks, for example, are common in the last 12 months. We're dealing with clients that have experienced those. And they can often happen because the controls, the security of a company has not been sufficient. Next. So just dwelling here a little bit on Spain, you've got a number of controls there, requirements there that are set out. The first one being control. Generally speaking, so this is where actually the AEPD actually came out and gave some guidance back in November 2019. And they did state, because there was some confusion around what role the parties in, let's say, a contractual relationship in the healthcare industry were playing. Generally speaking, you should consider yourselves controllers. I think if you are processing personal data for a reason that is, to do with providing health services. Not always the case, but generally speaking. You need to have a legal basis. Obviously, we know that. I covered that earlier. You need to be transparent. That is a key requirement. As I mentioned, that's often managed by way of the privacy notice, which needs to be very detailed as to what you're doing with the data. Purpose limitation. So that's something that's interesting in the guidance. Ordinarily, under the GDPR, you need to have a particular basis for each purpose for which you're using the personal data. The AEPD said that in certain circumstances in the healthcare industry, there may be reason to actually have a lawful basis for more than one purpose. Exceptional circumstances, nonetheless, but it may be possible. Next. Clinical trials and research. In particular, I've picked out these because they're particular areas that I come across when I'm working with clients in the healthcare industry, and they are ones that do cause some debate or are queried. So the first one being clinical trials. One of the key things there is the role of the parties, and a lot of clients get it wrong, I will have to say. So you've probably heard talk of a sponsor and the CTO, and which party plays what role is key. Generally speaking, if the sponsor is also making decisions, because ordinarily it's the CTO that is controlling the personal data of the patients whose data it's processing for the trial. But if a sponsor is also making decisions about that data, they can be a joint controller. It's not often, but they can be. Lawful basis, you do have to bear in mind that sometimes consent is, although it may seem the easiest and the most appropriate, it is not always, because you have to be able to withdraw your consent. And sometimes, depending on the trial, one individual withdrawing their consent to participate could put the whole trial at risk and could mean it's not successful. You should be conducting a DPIA, that's a data protection impact assessment. That's to analyze where there's large scale usage of personal data, and that's often the case in clinical trials. Any transfer outside of Spain or the EEA to another third country needs to have an appropriate safeguard in place mechanism. That's Article 45 GDPR requirement, absolute. Next slide. Research is also very popular, obviously, in the healthcare industry. I've just set out a few key issues that we come across that if you are looking to use healthcare data for research, these are the factors that you should bear in mind. Next. There we have just key takeaways for you today in terms of personal data and what you need to think about. You need to understand what personal data you're processing, where, why, and how. And you can then put a compliance piece in place, a compliance program, and ensure that you are complying with all the legislation and ensure any employees are too. That concludes my presentation today. I hope it wasn't too rapid, but thank you very much for listening.